lightning did strike yesterday evening when the 2-1 decision came out of the Fifth Circuit vacating the DOL fiduciary rule. I can tell you that all of us have been spending immense amounts of time trying to figure out what this decision means, what its implications are, and they could be broad. So let me first ask Karen, why don't you just describe the decision and your sort of initial impressions of it?
It is a very strongly worded decision vacating the entire rule. It struck down the rule really on a number of grounds, including that the DOL's interpretation was unreasonable, that it was not entitled to deference because it was unreasonable, that they mistakenly treated salespeople as fiduciaries, and there was no basis to do so.
Basically, the DOL has the authority in their statute to impose a fiduciary duty on someone that's giving investment advice. And where they got hung up, the court, is basically, I think, the two judges in the majority sort of have this as though Glass-Steagall still exists. And the last 20 years have sort of not happened in the financial services industry. Because they basically said that a broker-dealer can't possibly be giving investment advice, and an insurance agent can't possibly be giving investment advice because they're salespeople. Where we all know that over the last decade or 2 decades, there's been this shift where everyone in the financial services industry goes by the title of, say it with me, financial advisor, which sounds to an investor a lot like you're giving them investment advice. And so I think there's sort of this fundamental sort of lack of awareness by the court, and I do hope the DOL will at least ask for an en banc review.
That I agree with Rick that I don't see this stopping the SEC from moving forward with its proposal. I think those of us in Washington have been getting the sense that proposal is pretty well baked. They're fully in. I mean, Commissioner Peirce was here yesterday and elsewhere earlier in the week already talking about it and demonstrating support for it. So I think we know that the commissioners are prepared to vote in favor of a proposal. And I think where it gets interesting is what happens with the DOL rule along the way, and does that change the movement in the SEC rule from proposal to adoption? So the sort of conventional wisdom in Washington here has been the Republicans are supporting the SEC's rule. The Democrats would be opposing it because it probably doesn't go far enough in their minds, but what's far enough if the DOL rule no longer exists? Do they come around and support it because absent the SEC rule, there's nothing? Or alternatively, do they push for more? I think that's really going to be the interesting thing, but I would fully expect to see the SEC proposing its rule in the next few months, first half of this year.
Even if the DOL rule is vacated and gone, the horse is out of the barn, or to use whatever other phrase you want. Broker-dealers and other folks who are complying with the fiduciary duty rule under the DOL as of June 9th went out to their clients with notices and told them, we're acting in your best interest. Now, are you really going to send a letter to your clients saying, never mind, I'm not going to act in your best interest? No, it's too late, right? So some of this is, some of this is not going to change real life, right?
Yes, there is still a question of statutory authority, and the SEC has good reason to be careful about this. I mean, they had their last rule overturned in 2007, so this has always been a lurking question. But it would take, I think, the industry, or I suppose perhaps consumer groups, somebody would have to sue the SEC for acting other than under their statutory authority, and I'm not sure that there's a, I mean, it's 12 hours old, so it's a little early to say, but I'm not sure there's a drive to do that. This is probably, from a broker-dealer perspective, the most friendly SEC they're going to see in a while. And this question has been around since, what, the 90s? I mean,
yep, 1999.
The industry ought to be very careful before challenging this yet again if it gets a rule that actually does allow it to maintain some of the things that are important to it. receiving commissions, principal trading.
I would agree. I think the SEC is going to move ahead, but I think it is going to be, I think the boat that it is on is going to slow a little bit, is going to throttle back, because the general counsel and others are really going to have to look at this thing from a different perspective. And at the end of the day, it wouldn't surprise me that we see something that is different than what we have been to date discussing.